Bill, I'm curious, with the decisions going on in Chicago about the recent gun bans, was there any surprise that the existing ban had been considered unconstitutional?
I wasn't surprised that the Supreme Court decided to basically apply the Second Amendment to the states. You know, initially 2 years ago, in their first gun decision, they said that in a case involving the District of Columbia, which is, of course, a federal jurisdiction, that the Second Amendment protected the right of a person to have a handgun in his or her house for self-protection, that was a basic part of the Second Amendment right. But the question that the Supreme Court decided earlier this month was whether the Second Amendment applied to the states as well. I think a lot of people don't realize that the Bill of Rights initially, as written, did not apply to the states. It only applied to the federal action. And so the court has sort of amendment by amendment applied the parts of the Bill of Rights to the states and said the states have to abide by them. And so what the court did earlier this month was say, yes, the states have to abide by the Second Amendment. Now, what that meant was that cities like Chicago and the suburbs that had handgun bans could no longer enforce them because that would be a violation of the Second Amendment.
Now, the new rules that Mayor Daley and the City Council have enacted don't necessarily restrict guns. That say that you can register a new gun each month, only one firearm. Plus, there are some now background checks as far as registering with the Chicago Police, and I believe there's one other organization you have to register with. And there are already lawsuits coming out against that. Do you see those kind of restrictions being held up in the court's eyes?
Well, I think that the Supreme Court, I think there will be lots of lawsuits to try to determine what are the parameters of this right to bear arms, individuals' right to bear arms. I think that the indications are from reading the opinions of the court that they will allow states and localities to set certain rules about where you can have guns and where you can't, and that it's very possible that Chicago's rules could be found to be constitutional. I think states will be permitted to have, decide whether or not they're going to have concealed carry laws. I think states that want to continue to have concealed carry laws probably will be able to do that. But I think there will be a lot of lawsuits that will sort of shape what is the extent of an individual's right to bear arms. The court has clearly said an individual should have a right to have a handgun in his house to defend himself or herself.
Now, the action of this is happening in Chicago, but I'm curious, is there anything that us downstaters should be looking for, or the potential fallout from this opinion and these actions?
Well, I guess it seems like it would be an opening for people in other parts of the state to try to weaken Illinois' gun restrictions. It seems as though there has been, in the political branches of legislatures around the country, there's been a real move towards permitting more people to carry guns under more circumstances. Missouri for many years had a concealed carry law, but then or had a law that said you can't have a concealed gun, but then passed legislation that permitted the carrying of a concealed weapon as long as you had certain instruction and had registered it in a particular way. So I think there is a move in a lot of legislatures across the country to permit broader, to allow people to carry guns under more circumstances. And I would would not be surprised to see that sort of thing, that sort of effort made in Illinois.
As the debate goes on about in Chicago and also in the state of Illinois about concealed carry, are there any major court opinions that we should be reading or keeping in mind that perhaps the court may go back to, since they usually do go on precedent?
I mean, I think this decision, even though it was a very narrow one, I mean, both of the decisions we were talking about, the one 2 years ago involving the District of Columbia and the one this year involving Chicago, they were both 5-4 decisions. The replacement of Justice Stevens by Elena Kagan, if that occurs, is not likely to change, won't change that vote, because Justice Stevens was amongst the dissenters who would not have applied the Second Amendment to the states, would not, he and the other dissenters basically would have upheld handgun bans like the ones Chicago and the District of Columbia had. So I think that even though it's a 5-4 decision, it's not likely to be one that's reversed anytime soon. I believe, although I didn't actually hear this myself, I believe Kagan indicated that she was not of a mind to reverse, to vote to reverse the decision if one member of the majority down the road is replaced by a more liberal justice. I mean, the most recent decisions, though, are a significant departure from the way the Second Amendment had been interpreted in the 20th century by the Supreme Court. They had said that initial phrase of the Second Amendment about the importance of having a well-regulated militia was a limitation on the right to bear arms, and so basically permitted very broad regulation of guns. That basically the right to bear arms was just in order to be able to have a functioning state militia, and didn't relate to an individual's right to have a gun in his house. So that is the way the Second Amendment had been interpreted in the 20th century, and so the most recent two decisions are quite a departure from that. But I don't see the court reversing direction again very soon.
Bill Freivogel, thank you very much for talking with us.
Thank you.